I'm going to call this one video the Erie Co. versus Tompkins. Swift versus, but it's two cases. Swift versus Tyson is very complicated. But ultimately what it says is the common law of the state does not matter to the federal courts. If we are adjudicating something under state law in the federal courts, a state common law can eat a big bag of rotten apples. What is state common law versus everything else, right? So you got positive law, that's your statutes, and then you've got some other kinds of law. For example, a judiciary committee can get together and publish a report that explains what the judiciary meant. That does matter. But whatever the judges have said, again, that's a big bag of rotten apples to the federal courts. And then Erie v. Tompkins happens. And the federal courts go, having two separate sets of common law related to state law could allow for a lot of inconvenience in terms of, one, research, and two, allowing different parties to get different benefits by suing in state versus federal court. So we're getting rid of that, which was the correct decision. You do not want someone to benefit from what court they sue in. As much as what you talk about in civil procedure is exactly that, the courts don't want you to get crazy amounts of benefit. And if you're getting that benefit, they at least want it to be available to all plaintiffs. And it wasn't in this case because there are other requirements like in-state versus out-of-state. So Erie v. Tompkins overruled Swift v. Taylor and basically said, nope, common law of the state rules now. I imagine that was probably annoying for a bunch of lawyers who knew everything about the federal common law of Massachusetts. It doesn't exist anymore.